Okay, this is Roger Hallam. I'm doing a podcast or recording anyway of my summing up at the court case that happened in January and February 2023. The court case was about prosecution of Beyond Politics or Burning Pink members who threw paint over various civil society organisations about 2.5 years ago. The reason I'm going to record my summing up is so that other people who are in similar court cases can see the sort of things that I said, and I'm hoping maybe other people will load their summings up for their cases as well, so we can start to develop some of the best arguments or ways to communicate our innocence. There is also the wider issue, of course, of pressurising the British judiciary or even the judiciary in other countries to realise that what we face, as I will summarise in my summing up, is an absolute situation which shouldn't even be getting to court because it's absolutely wrong to destroy the human race, to be blunt about it. So that's my orientation when I was doing this trial. Was it's very easy to get bogged down in various legal technicalities, and these are important, and I do cover some of them in my summing up. And but the broad point is the big picture, of course, the enormity of what we face and the absolute criminality of what we face. Okay, I'm just thinking about saying one or two things about the case so you can understand what I'm going on about. The first thing to say is we weren't allowed to present a right of necessity defence, i.e. we had a necessity to cause harm to prevent greater harm. We had to do a consent defence, which broadly means does the jury agree that we believed that if the NGOs and the civil society organisations had known the full circumstances of the situation at the time, they would have given their consent for us to throw paint. So as you can see, that's a bit of a convoluted construction to get your head around to communicate to a jury, but that's what we argued on, and so that's, you can see that's how I'm making my arguments. Though these arguments can be reconstructed to be made in a right of necessity type defence as well. So it's just a matter of how they're presented. I refer quite a lot to the dog. So there's an example in law that a dog was in enormous pain. A person killed the dog to put it out of its extreme misery, and the owner would have consented if they'd known the circumstances, i.e. the dire pain that the dog was going through. So I use that in my summing up as a sort of case of what innocence should look like. All right. Anyway, I think I'll leave it at that for the moment, and I'll just trundle through this summing up. So I'm not going to do it with a massive amount of rhetorical spiritedness, as you might say, not least because I'm recording this down a telephone line from Pentonville Prison in the UK. So I don't want to disturb my cellmate too much. Anyway, so here we go. So, but hopefully you'll get a flavour of what I was trying to put forward. Okay. I'd like to speak to you today, first of all, about an important interview that happened in the 1950s. It was a BBC interview of Lady Mitford. Lady Mitford was the wife of the leader of the British fascists in the 1930s. And in the interview, Lady Mitford was asked what she thought about the murder of 6 million Jews in the Holocaust. And Lady Mitford answered, "Oh, I don't think it was that many." And the reason I mention this is because self-evidently what Lady Mitford was trying to do was avoid dealing with the absolute obscenity of the Holocaust by diverting attention into the technical issues of exactly how many people had actually died. Now, I'm not suggesting for a moment that people in this court have a similar opinions to Lady Mitford, but what I do want to say is there's something very disturbing and even sinister about running a court case where so much of the time over the last 5 weeks has dealt with the technical issues of who had which paint and which buckets and who was where and when. I'm not saying that this is not important, but what I am saying is we all need to face the reality that the enormous elephant in the room, as you might say in this trial, is the catastrophic criminality of putting carbon into the atmosphere to the point of destroying civilization and the human race. So what I want to do is make clear that the heart of this case is to do with consent. Whether these organisations would have given us, whether we believe these organisations would have given us consent to put paint over their properties. Because if we're found, or I'm found not guilty of that charge, then obviously all the disputes about photographers and various people who may or may not have been involved in the conspiracy is irrelevant. So what I'm going to focus on is this sentence in law that I'm sure everyone in this court has read many times, that the question before you as a jury is, do you believe, did I believe, genuinely believe, that these organisations would have consented to the actions we took if they knew of the full circumstances? So what I want to focus on are 3 key words in this summing up. The belief, my honest belief. The circumstances, if they'd known the circumstances. And lastly, the word known, to know. What does that mean? Okay, so let's start with belief. Now, it's interesting that the judge has just done a summing up of what is involved in the law on consent and what is not. And you will have noted, and if you need reminding, it's in points 88 and 96 in paragraphs in his document, that giving consent, belief in consent, does not involve using the word consent, actually saying it or writing it or thinking it. It's about, is there a defence in law that you have a belief in consent? Similarly, there's a sort of confusion that the defence, the prosecution have promoted, which is that at the time of the actions, I had a belief that they would have given consent. And at the same time, I envisaged the moment in which they would give that consent would be at some point afterwards, if for no other reason that it was very unlikely that the owners of the property or the heads of the NGOs would have been physically present at the moment. Now, those 2 things can be completely legitimately combined, and it's interesting that the prosecution has focused exclusively on the technicalities of consent and belief and ignored what the judge has made clear, that we don't need to use the word consent and that the belief in consent is a defence which is available, which can be communicated by a lawyer and what have you after the act has actually happened. So just to reinforce this point, let's look at this famous example, which is about a dog who is killed in order to put it out of pain. So as you'll note from paragraph 90, the law it's in law that this case would have been a valid defence. But if we think about it in terms of what actually happened, it's fairly obvious that the owner, that the person who came across the dog, was not thinking about the word consent or even thinking about the notion of consent as such at the point at which he killed the dog. He was probably just thinking that it was the right thing to do. And then subsequently, it's quite possible, of course, that he would meet with lawyers who would tell him that he could be prosecuted for it, but in British law he had the right of consent. And then the question would be put to him if at the time did he believe the owner would give consent, and of course he would say so, and it would go to court on that basis. And that's no problem. There's no issue or problem with doing that. So what I would put to you, members of the jury, is that what the prosecution is doing is focusing on insubstantial matters, technical matters which have no particular relevance in the law in this case. If there was an actual case, if the prosecution had a real case against our belief in consent, then they would have questioned the substantial evidence which was presented. So, for instance, they might have said, well, Mr. Hallam, you didn't spend 5 years at King's College studying non-violence, and the notion that you engage with an opponent in the belief that they would give consent if they knew the circumstances. Nor did they produce evidence, for instance, that I actually enjoy throwing paint over buildings, and there's photographic and written evidence to show that I just like throwing paint and vandalising things. Now, if those 2 points were confirmed, that would be substantial evidence to undermine the notion that I had a belief in consent. But you will notice, members of the jury, that not once did the prosecution, did Ms. Wilson, the prosecutor, raise any issues about my background, my beliefs, and the activities that show substantial evidence that I believed in consent. She didn't say anything about my being brought up in a religious and moral household. She didn't raise any issues around my experience of injustice in India, where I experienced people being shot and such like. Nor was there any questions about my studying of Gandhi and Martin Luther King, whose philosophy of action is very much based upon the notion, as I've mentioned, of disrupting an opponent with the belief that they would have consented if they knew all the circumstances. Nothing was said about my work at King's College, looking more into this way of engaging in activism, nor anything about the actions that I designed for the trade unions, where a trade union occupied the clients of a courier company, and that action was deliberately aimed at the notion that the customer of the courier company, if they knew all the circumstances, the exploitation of couriers in London, they would have given a consent, and that's indeed what happened. They phoned the courier company demanding that they give the couriers a decent, legal pay settlement. Similarly, my design of the XR Extinction Rebellion episode in April 2019, again, the belief of that project was that the government would have given consent if they'd known all the circumstances, and you have the evidence of that when the British Parliament declared a climate emergency directly caused by those events. And the prosecution has said nothing about the design of this campaign, which specifically focused on the creation of disruption leading to dialogue and reconciliation. In other words, believing that if the NGOs had knew the full circumstances of the climate catastrophe, they would have given consent. So this leads us on to the statement by the co-director of Greenpeace. So as members of the jury, you will remember probably, in my view, the most important moment in this court case when I asked the co-director a simple question, which was to quote directly from the law. Would you have given consent to the throwing of paint over the headquarters of Greenpeace if you had known the circumstances of the climate catastrophe? And the director of Greenpeace, the co-director of Greenpeace, as you'll remember, replied with a single word: yes. So I put it to you that there's no confusion there, and the charge that we are charged with is that we conspired to cause criminal damage without lawful excuse. Where you've been asked by the judge to use your common sense, and I would suggest if you use your common sense, it's clear in the case of Greenpeace, on the basis of what the co-director has told you, that there was a lawful excuse because the owners of the property subsequently have given permission, and there's no victim. If there's no victim and permission was given, then surely from a common sense point of view there can be no crime. And then if I refer you to paragraph 104, you'll note that on count 1, the throwing of paint over for NGOs, if one of those NGOs clearly has given permission and clearly would have consented at the time if they'd known the circumstances, then whatever you think about throwing paint over the other 3, Amnesty, Friends of the Earth and Christian Aid, is irrelevant, because you have to find myself and my other co-defendants not guilty on the basis that the Greenpeace part of that count is clearly a matter of us not being guilty. Incidentally, this obviously, as the defence lawyers have mentioned, has implications for the conspiracy to throw paint over the trade unions. Obviously, this did not happen, but given that the director of Greenpeace used the word trivial, where referring to water-based paints being thrown over their doors, I put it to you that you cannot be sure that trade unions similarly would find the amount of damage trivial and would not wish to have a criminal court case brought against the people that have done it. They would have recognised that we believed at the time that if they'd known the circumstances, they would have given consent and they would have given permission and entered into dialogue with us. At least you cannot be sure that they would not. And as the other defence lawyers have said several times, and I don't want to reiterate this too strongly because you've heard it lots of times now, but just to be clear, you have to be totally sure. To quote what the judge said in paragraph 67, it's up to the prosecution to prove guilt. We are innocent unless they can prove our guilt. You have to be sure that we are guilty. If you're not sure, then we're not guilty. So I put it to you, on the case of Greenpeace, you simply cannot be sure. In fact, I put it to you that you can be sure that they did give permission and they would have given consent, because that's what the director said. So that's what I wanted to say about the belief word. So the next word I want to look at is circumstances. They would have given their consent. I believe they would have given their consent if they had known all the circumstances. So probably for me the most important revelation of this court case, apart from the Greenpeace interview, was the follows, was this, that through this whole court case there has not been one single question by the prosecution, by Ms. Wilson, on any of the evidence around the circumstances. In fact, Ms. Wilson has said she believes the climate crisis catastrophe is real, but she has added in a rather Mitford-style comment that this, however, is a matter of opinion, that it's a cause. Well, I put it to you that science is not a matter of opinion. The ice melting in the Arctic is as real as 6 million Jews being killed in the Holocaust. And what we are dealing with here is a reality, a physical reality. Now, I'd like to refer you to what the judge has said in paragraphs 92 and 93. So, in 92 he says, there is no reason circumstances cannot be more complex and involved. In other words, this is not a matter of something being so big it can't be given consent. It can be complex and it can be involved, and you can still believe in consent. In fact, the circumstances are an essential element, to quote the judge in this trial, even though nothing has been questioned by the prosecution. Also, the judge has said the circumstances are what they are. The circumstances are what they are, meaning independent of the defendant's belief in them. In other words, a crucial part of this trial is what are the circumstances and how significant are they? So how I suggest we structure our analysis of this is again referring to the legal case of the killing of the dog. So it's clear in this case there are two sides. The person who killed the dog presumably found the dog. The dog was in enormous amount of pain, and he did something that caused harm. He killed the dog in order to prevent the enormous suffering, i.e. the great and extensive harm of the dog suffering hours, if not days, of misery before dying. Now, if this case went to court, you can imagine that these circumstances being conveyed to the jury. But I want you to consider what would happen if the prosecution stood up and said, well, this is all very well, but we have substantial evidence that in fact the dog only had a scar, a graze on one of its legs. And although it was in some pain, it wasn't in excessive pain, and it certainly wasn't going to be in excessive pain leading to death. Well, it's common sense that this would be a massive revelation of the independent circumstances of the case. And you can imagine if the jury would have not found it credible that the person that killed the dog believed the owner would have given consent to kill their pet if there'd just been a graze on the leg. In other words, circumstances count in terms of whether a jury finds a person believing in consent guilty or not guilty. So what we need to think about here then is, to generalize, is the harm caused and the harm prevented. There was a finite amount of harm that was going on, and then or a finite amount of harm that was created. to prevent a far greater finite amount of harm. So let's think about this in a more systematic way. Let's say that myself and my 11 co-defendants went to a big international airport, and we threw paint on the regulator of the airport that was responsible for health and safety, for the safety of the passengers and such like. And it came to court, and the defence presented to you, the jury, the defence that that the 12 of us believed that the regulator of the airport would have given consent if they'd known the circumstances. Well, the big question in the room, of course, is what exactly were those circumstances? So let's look at 4 different possibilities. Let's say, for instance, that we, as very moral and ethical people, were horrified that new planes were going to be introduced, which would lead to 1 in 11 million people dying. Well, the prosecution would be straight on their feet to say that is no different than the number of, the probability of death of flying a plane at the moment. And it might be of concern that some people occasionally die on aeroplanes, but there's no credibility in the assertion that the 12 of us believe that the regulator would have given consent to paint being thrown over their building just to inform them of a minute possibility of harm. So the harm created by the paint was a lot greater than the knowledge that very few people die in plane crashes. So you as the jury would be minded to find us guilty in those circumstances. Similarly, if it turned out that these new planes that were going to be introduced would result in a 1 in 100,000 chance of dying in a plane crash, well, you might say that this was of, public concern, and it should be dealt with through the democratic process and maybe setting up a normal campaign. But it's not credible that the regulators would want paint thrown over their building just to inform them of a ongoing area of public concern, namely the increasing numbers of people who are going to die in plane crashes. So again, on balance, you as the jury might be minded to find us guilty. However, what would happen if the defence produced independent, substantial evidence that the new planes that were going to be introduced would lead to a 1 in 1,000 chance of crashing? Well, that would mean, 2 or 3 plane crashes a week over the British Isles. That would be a scandal of national proportions, and the regulators would have been horrified to find out these circumstances, and no doubt they would have thanked the 12 of us for throwing paint over their properties to inform them of these objective circumstances. And you, as a jury, no doubt would therefore find us not guilty. And just to finish off, if there was a 1 in 100 chance of planes crashing, then it would no doubt be the scandal of the century, and no doubt there would be a statue of Valerie put up in Parliament Square along with Mandela and Gandhi for public service. What I'm saying here then is it all depends here on these circumstances which are independent of the defendant's beliefs, as you have been told by the judge. Now let's just take this thought experiment one step further and think about what you would have thought if there was a 1 in 1,000 chance of a crash, and the prosecution had stood up and said, well, we have substantial material evidence that, in fact, all these flights will be coming from the global south. And implicitly, or maybe even explicitly, the prosecution made the point that we don't really need to care about dark-skinned people, poor people from tropical countries, because they're not quite worth the lives that our lives are worth. Well, you can imagine this would be a totally outrageous argument, and maybe some of you, as members of the jury, would walk out in disgust at the implied racism. Or maybe the prosecution would have got up and said, well, we have substantial evidence that these planes aren't actually going to be introduced for another 5 or 10 years, and so the deaths primarily will be deaths of our children, people who are young now. So implicitly or explicitly, they may imply it doesn't really matter. Well, again, this would be an absolute obscene argument, similarly to Lady Mitford's technical points around the Holocaust, where you can see what I'm implying here about what is a, obscene situation and what is not. Okay, so we've looked at a thought experiment, as it were, of how you, the jury, would react to the airport situation. So let's look at the circumstances of the climate crisis. Again, remembering that these circumstances are independent of the defendant's belief in them, to quote the judge. So these are objective, indisputable facts. The first one is that we are now undoubtedly heading over 1.5 degrees of global warming. This has been confirmed by numerous scientists and international bodies, and so it's going to happen unless you want to split hairs in a Lady Mitford sort of way. In addition to that, when I presented my defence evidence, I gave you peer-reviewed paper quotes from numerous sources that provide information about what's also locked in, what's definitely going to come down the line. What's not a threat, it's actually going to happen, and this is the carbon lag, global dimming, the melting of the Arctic, and this requires you to add on another 1.5 degrees, maybe more, maybe a bit less. Now, just to remember, Ms. Watson, the prosecutor, did not stand up and question this. If she'd done some of her homework, she could have questioned whether it was 1.5 or 1 degrees that needs to be locked in. And I would have been forced to reply to her that these are indeed estimates, even though they're in gold standard peer-reviewed papers, meaning, of course, they could be higher or they could be lower. The main point, of course, is that they're absolutely horrific, in the same way as the 6 million Jews could have been higher, could have been lower. That doesn't change one bit the absolute horror, injustice and obscenity of what is happening. Then I also mentioned that you also have to add in methane, which once we get to 3 degrees adds in another 1.5 or so of global warming due to the melting of the permafrost. So that takes us up to 4 degrees, and you heard from the world's top scientists of 4 degrees, we're looking at billions of deaths, thousands of millions of deaths. Again, if we don't want to engage in a Lady Mitford hair splitting, we could be saying 6 to 8 billion deaths, according to the scientists that I quoted. On top of that, that wasn't as horrific beyond description, is the tipping point situation that takes us to hot house Earth, many degrees higher than we are now, which guarantees human extinction. These tipping points, again, according to gold standard peer-reviewed research, look in around 1 to 3 degrees. In other words, below where we're already locked in to get to. Ms. Wilson did not question this, and so you, as the jury, have to conclude that there's a substantial possibility if not inevitability, of the collapse of civilization in the next 2 to 3 generations, leading to a substantial possibility of human extinction. It's worthwhile noting that if there's a possibility of something infinite, like a 10% chance of infinity, then that is still infinity according to the mathematics of infinity. And you will remember, I hope, on paragraph 12 of what the judge told you was the jury has to be dispassionate. You have to be logical and you have to put aside your prejudices. If you're told something horrific, it's not an option to pretend it doesn't exist. We know what this is like because many people have experience of themselves or their loved ones getting cancer, and you come out from the meeting with the doctor and the doctor says you have 6 months to live unless you have chemotherapy or such like. That means it's real and you have to take responsibility for that. When it comes to looking at this sort of evidence in a courtroom, it's not just your moral responsibility, it is your legal responsibility to look dispassionately at the facts. And the facts of the matter are undisputed by the prosecution that we have a substantial chance of heading into human extinction, an absolute level of harm to be compared with the infinite amount of the finite amount of harm caused by throwing paint on NGOs and civil society organisations who are supposed to be promoting the interests of society. What this means then is we face no greater crime, or as a leading London lawyer said, there is no greater crime. There is no greater crime. This does not mean it's a monstrous crime or a most terrible crime. It means in the whole of human experience there has been no greater crime than to engage in putting carbon into the atmosphere to the point where you lock in 4 degrees, the collapse of civilization and the substantial probability of human extinction. There is no greater crime. So I put it to you as members of the jury that you have to be 100% sure that I believe that the organisations would have given their consent if they had known these circumstances independent of my belief, rooted in the objectivity of the geophysical system as we find it in 2023. In other words, you don't have to be like a degree of unsureness. You can be 100% sure. Of course, you know from what you've been told that you have to be sure that I did not believe this, but you can be 100% sure that I did. In other words, the opposite. There is only one way I would suggest that the prosecution can try and wriggle out of this absolute point, and that's by suggesting that knowing the circumstances requires just having a look at a few facts on a piece of paper. But I would refer you to the paragraph that it says known. It doesn't say what known means. So we can be reasonable about this and assume that it doesn't mean simply giving information. Giving information is one way of knowing, but it's by no means a conclusive way of knowing. So, for instance, when you find something that is very distressing, often you have to see it as well as receive information about it. For instance, coming back to the example of the dog, you can envisage the idea that the dog was killed and the owner was very upset, and she needed to see the dog and the injuries that it sustained in order for her to believe that the person who killed the dog did genuinely think she would have consented if she'd known the circumstances. But to do that, she'd actually have to see the injuries as well as read about them on a piece of paper. Of course, this is part of a long cultural tradition in many countries, and not least our own, where people see the body of a loved one in order to enable them to believe in a more concrete and visceral way that indeed the relative or loved one is indeed dead. You actually see the body. And I'd also refer you to a famous case in World War II when an American judge, when being told about the Holocaust, the death of people in the concentration camps in Germany, said words to the effect that he knew what was happening, but he did not know what was happening because he couldn't viscerally understand the horror of what he was being told. In which case, of course, it would help if he actually went to see the death camps, and then he could genuinely have the knowledge, of the circumstances. So as a general rule of thumb, knowing depends upon the emotional intensity of what it is that needs to be known. So for instance, if you want to know when a train is leaving Euston Station, you just need to look at the information. You don't need to go to Euston Station and actually see it on the board because it's of no great emotional importance. However, if something's deeply emotional and horrific, and what could be more emotional and horrific than the climate crisis, then it would be a reasonable assumption, or at least you cannot be sure that knowing would not mean actually seeing and witnessing the horror with your own eyes and ears. To this extent, then, I would suggest that what a reasonable definition of know means in these circumstances would be to go on a short tour around the world and actually hear and speak with the victims of this enormous, indescribable injustice. For instance, I would take the NGO leaders to Africa to speak to people in refugee camps who'd lost their farming communities where they'd farmed for thousands of years. I'd take them to northern India, where farmers are suffering from a epidemic of suicides due to the stress of massive droughts. I would take them to the North Chinese plains, where agricultural workers are being forced and will be soon forced to work in temperatures that could lead to their deaths. Closer to home, I'd take the NGO leaders to teenagers who are suffering from mental health problems due to their feeling of being abandoned by the older generation under climate catastrophe and engaging in self-harm and other forms of self-destructiveness. And last and not least, I might take them to speak to Conservative MPs who privately are having sleepless nights because they are terrified of what the crisis means for the economy and security of the United Kingdom. In short, I put it to you that if the leaders of these civil society organisations had a real sense of seeing and knowing of what is coming down the line, no reasonable person, no person who is not psychopathic would inevitably believe that would give consent to some paint being thrown over their buildings in order to wake them up to these beyond horrific circumstances. So, before I finish, I'd just like to make a point which is not about law, it's a moral point, and it refers to a famous court case after the English Civil War when a jury was instructed by a judge to find a group of defendants guilty of a crime. I think it was a group of Quakers. The jury refused and decided they were innocent, and the judge had them put in the Tower of London and insisted he would only let them out when they agreed to come up with a guilty verdict. It went to an appeal court, and in a very significant moment in our country's constitutional history, it was decided no judge can lawfully imprison a jury for coming up with a decision about guilt or not guilt that he disagrees with. The point being, of course, is that if the defence lawyers, for instance, speak their minds in this courtroom, they may lose their jobs or be ostracised. If I tell you what I really think, then rightly or wrongly the judge might be able to put me in prison for contempt of court. But whatever you decide as members of the jury, no one could touch you. In other words, you have enormous power, and with that power comes enormous responsibility. You, in fact, are now part of the story. And as you can see, this court case is not about some mundane crime. It's about the most enormous crime imaginable. It's therefore reasonable to expect that the outcome of this court case will be studied by teenagers today in a decade or so, and they will look at the outcome of this court case and to see what juries thought about their right to a livelihood and a right to a life. And it's not unreasonable to believe that over the next 100 or even thousands of years, people will look back at this period in the early 2020s to ask again, what did juries in cases like this decide? In other words, history is looking at you at this moment, and you have this enormous responsibility on your shoulders. It is what it is. So let me say again, why did I believe that these organisations would have consented if they'd known the circumstances? Because of the circumstances. Let me sum it up in 4 different areas. First of all, we are looking at the destruction of the United Kingdom, our country, the destruction of the state, the destruction of the rule of law, the destruction of Ms. Wilton's very attachment to property rights. As we know that London will have to be evacuated, it's just a matter of time. So much for the property rights of 8 million Londoners. Secondly, we are looking at the betrayal of our children, our kids and their children and their children. They face a world of great distress with the possibility and possibly the inevitability of starving to death at some point later this century. We are looking at the denial of the most basic human rights to the poor of the world, billions of brown-skinned people in the tropics. Nothing could be more unjust than imposing such horrors on them which they have not had any role in creating. And last but not least, we are looking at the destruction of the natural world for the next 100,000 years, because once carbon is in the atmosphere, it can't be taken out, or there's no guarantee it can be taken out. Think about this. This has to be undeniably the greatest crime in the history of humanity. And I ask you a simple question. Can you be sure that I did not believe that these organisations would give consent to our actions given these circumstances? Thank you.